and welcome to Liberty Nation TV. I'm your host, Mark Angelides. It's been almost a decade since the Supreme Court has addressed a Second Amendment case, and it appears that come fall they may have to again, but there's a wrinkle. To explain that wrinkle, we're joined by Liberty Nation's legal affairs editor and man about town, Mr. Scott D. Cosenza. Good to have you on, Scott.
Cheers, Mark.
So this case, I'll be honest, I'm lost on it. I'm not entirely sure what's happening. Could you give some background on this?
Certainly. So just to sort of adjust your diction there in the intro, it's not that they may have to, they choose to. So the Supreme Court chooses the cases that they take, and that's a very important component to the story because they haven't chosen to take in a Second Amendment case in 10 years. Now, that's not to say there haven't been many disputes that the litigants would have liked for them to take surrounding the Second Amendment, but they've chosen not to take it. We presume for the host of reasons. I think there's political reasons and practical reasons why they don't want to do so. But Justice Thomas himself, I think it was the last term on the court, or maybe the term previous, actually lamented the court's refusal to consider Second Amendment cases. So that's sort of the backdrop for the story. The case itself involves the New York State Rifle and Pistol Association, who have sued the city of New York, Mark, one of the most, basically it's one of the hardest places in the United States to lawfully have a gun. And New York State, that New York City law, rather, forbade citizens from New York City who legally owned firearms from doing anything with them except traveling to one of the 7 ranges that are owned in the city and back. If they owned a vacation home, they couldn't take the gun to the vacation home. If they traveled to an area where they wanted to shoot outside of New York City, where it was perfectly legal to do so, they were forbidden by law from doing so. And they sued to say, hey, we own these guns legally. We'll transport them legally. Why can't we go ahead and go to Pennsylvania and go hunting on my brother-in-law's farm? Well,
I have a question based on that. How would that be enforced? Let's say, for example, this all went ahead as far as New York City wants it to go. And then a person, say, for example, yourself, say you're in New York City and you take your firearm to Pennsylvania to go hunting. Who enforces the New York City law?
Well, only New York police officers sworn to uphold the laws of New York that are in New York could legally uphold that law. So in Pennsylvania, if I was legal to have the gun in Pennsylvania, for instance, then I would not be subject to arrest in Pennsylvania, but I would be subject to arrest in New York. So perhaps if somebody saw me shooting on social media and Facebook or Instagram posts, they could, file a complaint against the police. If I was pulled over by the cops for any kind of a traffic infraction, and they asked if I had any weapons in the car, and I told them I did, as I'm sure the New York City laws probably require people to do when transporting, then I could be arrested. And they're very, very harsh with gun owners. It's not like some kind of idea where it's like, well, yeah, you probably didn't understand the regulation, but obviously you're a good person, having gone through this incredibly onerous process to legally own a gun. No, it's the exact opposite of that. It's the authorities in New York who will grind and punish anyone who dares to try to basically honor their or exercise their Second Amendment rights. So that's what the case is about. And in fact, Mark, the reason why the law was changed after the Supreme Court said that they would accept the case for review, we presume is because those legislators are so scared that the Supreme Court will articulate a greater protection for Second Amendment rights for the people, and they don't want to do that. And so they basically changed the law in order to make this case moot, or make it so that the Supreme Court would say we can no longer decide it because it's not an actual case or controversy, so we'll just move on to the next thing.
So what are the senators saying about this? Are they still behind it, or are they working with New York's lawmakers to try and do a workaround on this?
Well, their involvement involves this mootness question. So because the law has been changed, the New York City and state authorities have gone to the Supreme Court and said this case should be dropped because the law has changed. There's no actual case and controversy anymore. The New York State Pistol Association challenged the law. The law has now changed. Now, the counter argument to that is, Well, they changed the law precisely to get it away from judicial review. And the governments have a lot of ability to kind of like pick and choose which cases can get judicial review because of their position sort of in the legal marketplace. As you might imagine, the attorneys for the state and the city of New York are not like private attorneys in terms of their, the cost involved to get them into an appellate case, right? So the New York State Pistol and Rifle and Pistol Association says you should continue to hear this case. This is them addressing the Supreme Court because there are other issues involved and other towns and cities and states involved that have similar restrictions. So you should hear this case. The most famous, I think, Mark, mootness issue case is Roe v. Wade. And if you think about it, the gestation time for human in utero is only 9 months. Well, it takes longer than that for a case to work its way up through the appellate court system. So if they would only take cases involving, for instance, a pregnancy when the pregnancy took place, the Supreme Court would almost never hear a case involving a pregnancy because the baby would have either been born or not by that time. So that's sort of a way to kind of wrap your head around the mootness issue. The brief was submitted by the key Democrats on the Senate Judiciary Committee, many of whom we know from the Kavanaugh hearings. It's Whitehouse, Blumenthal, Mazie Hirono, the bigot, and Richard Durbin from Illinois, and Kirsten Gillibrand from New York. So they've sent this brief, an amicus brief. They filed it in the case with the Supreme Court. And Mark, it is, to say that it's shocking, I mean, legal briefs are generally fairly staid, humdrum sort of things, dry reading, if you will, right? Especially for those of us that are not terribly interested in the issues discussed. I mean, for me, it may be a little bit more of a bump, being kind of a legal nerd and a lawyer. But this is spectacular. They have said that the Supreme Court basically has been ideologically bent. In other words, this is the focus of the brief. The brief itself is supposed to argue points of law for the Supreme Court to consider. But instead, they've made a political argument in the brief, and they've concluded with saying that hopefully the Supreme Court can kind of straighten out the mess that is their own Second Amendment jurisprudence, or they'll pack the court. They will add justice. They didn't say that they themselves will do it. There's kind of a veiled language that the people will see that the court, that they're going to add justices to the court. It's breathtaking, Mark. Honestly, I think for U.S. senators on the Judiciary Committee to send basically a note in the form of an amicus brief to the Supreme Court threatening them.
I mean, with that particular issue, the idea of packing the courts, I know you and I have discussed this before, and I think that should actually be done, but they should do it today, right now, while President Trump is still in office, and let him pack the courts. Because if the courts are packed, that's the purpose, isn't it?
Mark, it's a beautiful suggestion of skullduggery that you've put forth. But as somebody who has to live in these United States after the court will be packed, I must say that I have to reject your. No, it makes perfect sense in terms of a screw you, or better said, it makes perfect sense in terms of if that's what you want, then let me give it to you right now, good and hard, right? That's what Trump can say.
Yeah, but the point is that this would expose any level of hypocrisy or personal power grabbing that they're aiming for.
I don't know that that's something they really are endeavoring to conceal so much. That seems to be out of the bag on that one. Yeah, that's part of what's sort of breathtaking about the. I keep wanting to call it a note because it is an amicus brief, so it's a brief, but boy, it's unlike any brief I've ever seen. It doesn't address the legal points in the case because, of course, why address those? Those are weak. Instead, it's better to address school shootings and massacres rather than the absurd, if I may be so bold, absurd law that New York City has imposed on its citizens.
So really, with this, as you say, it's now a question of mootness. But the Supreme Court, they've still got until October to decide whether to hear this case or not. Is that right?
Well, they've got longer than that. They set their own rules, so they can just go ahead and basically issue a notice that they're going to consider whether they're going to
so they're going to consider
give oral arguments or not. And right now we're in a holding pattern. We're waiting for the court to decide for themselves how they'll proceed in the case. And that was the attempt by the senators, was to influence that decision making.
So what should the court do? Not only in terms of what should they do regarding should they considering the actual case. But what should they do in response to these senators who are making very, very thinly veiled threats?
Well, in regards to the senators, they have free speech just like anybody else, and they're entitled to file or ask for leave for filing of an amicus brief. I would say that what the court should do in that case is they actually have to grant permission for a brief to be filed. In other words, you can't just file an official brief in a case that you're not a party to in the United States Supreme Court and have that be part of the record. But you can ask the Supreme Court for leave to file that brief. So they have to get permission from the court to file it. So I would deny them that permission and make it just a kind of sort of out there in the wind, and that would be an appropriate, I think, rebuke to a non-legal brief filed. Beyond that, I think we don't want the court to get involved in any kind of tweeting or anything in terms of a tit for tat between them and the senators. And then in terms of how they should actually handle the case itself, I think it's a fascinating issue. Obviously, I think I'm wildly sort of pro-Second Amendment and pro-gun. So for practical concerns, I would hope they would strike down this law. But in terms of whether it's should be heard anyway because of the mootness argument or not, it's a bit of a sticky wicket. I'm not sure, Mark. And I hate to just, because I think it might go my way on the Second Amendment issue, argue that it should go that way on the mootness count.
Well, Scott, thanks very, very much. I actually feel like I understand this a bit better now, which was not my feeling going into it. Scott,
happy to help.
And thank you at home for watching. If you enjoyed this video, make sure to click the like and subscribe buttons. And of course, follow us on libertynation.com, where we've got podcasts, radio, TV, and our most important treasures, some well-written, well-reasoned, analytical arguments. All that and more on libertynation.com. Thanks for watching.